Mouth. Okay, my name is Tim Heise. Thank you so much for coming. I'm a law student here, 2L at the School of Law, and I'm on the board of the Federalist Society. We like to host debates here, win or lose on the idea. We like to just have debates, open and honest discussion. And so thank you all for coming. Tonight's debate, or this afternoon's debate, is obviously on gun control. And we are excited to be hearing from Dr. Jack Russell Weinstein and Ms. Sandra Froman. I'm going to talk a couple things, just say a few words, and then we're going to talk about the format and just get started since we don't have a lot of time. First of all, while you're listening to them, please think of questions. We will have a question and answer session at the end. The format will be as follows. Dr. Weinstein will be starting for 15 minutes, followed by Ms. Froman for 15, and then 2 10-minute rebuttals, and then 10 minutes of question and answers from questions from the audience. And so, without further ado, I'm going to introduce our debaters. Dr. Jack Russell Weinstein is a professor of philosophy here at UND, and he is the director of the Institute for Philosophy in Public Life. He received a PhD in 1998 from Boston University. He is the author of 3 books, including the forthcoming Adam Smith's Pluralism, Rationality, Education, and the Moral Settlements from Yale University Press. He has published several edited collections and dozens of papers in journals ranging from economics and philosophy to the William Mitchell Law Review. He is also the host of the public radio show, Why? Philosophical Discussions About Everyday Life, which I am a listener of. Ms. Sandra Froman is an attorney in Tucson, Arizona, whose practice includes business, contract, and employment litigation, as well as mediation and arbitration. She is a member of the National Rifle Association Board of Directors since 1992. She served for 7 years as a vice president and 2 years as the president of the NRA, after which she was unanimously elected to the NRA Executive Council for life. She is only the second woman elected as president since the NRA was founded in 1871. She has been a partner at prominent law firms in California and Arizona and was a full-time law professor at Santa Clara University Law School for 2 years. She serves on advisory boards for the University of Arizona, James E. Rogers College of Law in Tucson, Arizona, and the George Mason University Law School in Fairfax, Virginia. She received her undergraduate degree in economics from Stanford and her Juris Doctorate degree from Harvard Law School. Let's give a welcome to both of our debaters.
Well, I'd like to thank everyone for coming. I appreciate it. I see some familiar faces, which is always very nice, particularly because planning for this debate has given me an unexpected surprise. I finally know how Rocky Balboa felt when they picked him out of nowhere to fight Apollo Creed. The Federalist Center has brought in a ringer, a former president of the NRA who spends much of her time going from gun control debate to gun control debate. She's being paid to come here. How much? I don't know. And to debate her, they found me, some local schlub who's willing to give up his lunch hour for free. In itself, that's not worthy of comment, but as a metaphor, it's really useful to describe the entire gun control debate, because the NRA is a high-powered, exorbitantly funded ideological organization that regularly steamrolls local public opinion and law enforcement. How strong is their lobby? Well, in the year 2000, the last time there was a serious gun control debate, the gun manufacturer Smith & Wesson agreed to settle some lawsuits and comply with government regulations. In response, the NRA organized a boycott that almost put them out of business. In the space of 6 to 8 months, Smith & Wesson plants were shut down, production lines were closed, and ultimately the company changed ownership. The NRA will claim that this is what the membership wants, but that's not true. 74% of NRA members support background checks. 75% believe that concealed carry permits shouldn't be granted to people who commit violent misdemeanors or assaults. 74% believe gun permits should only be given to people who have completed gun safety training. 68% believe being arrested for domestic violence disqualifies someone from gun ownership, and half support a 5-day waiting period, but not the NRA leadership. Their position is purely ideological. My intent is to show that the NRA position is untenable. I don't expect to persuade anybody. I really don't know if Americans ever change their mind on anything anymore. But I will argue that gun control and the Second Amendment both have histories, and that every time gun rights advocates assert that ownership is guaranteed without qualification, they're wrong. I'm not a constitutional scholar. I'm not a lawyer. My interest is in the relationship between theory and actual events, and that's the approach I plan to take. To begin with, almost everyone in this room is pro-gun control. Most of us believe that people shouldn't own tanks, surface-to-air missiles, grenades, or Molotov cocktails. So the question is not whether there should be gun control, but how much. Obviously, I think there should be more. So incidentally did the NRA for the vast majority of its history. The National Rifle Association was founded, as Tim said, in 1871 to promote gun skills after witnessing the poor marksmanship of Union soldiers during the Civil War. In the 1920s and 30s, they wrote and lobbied for gun control legislation, leading to the Uniform Firearms Act, which banned anyone without a permit and a proper reason from carrying a concealed gun permit. It also supported the National Firearms Acts of 1934 and 38, which taxed guns, required registration for some, and created a licensing system for dealers sending guns across state lines. In fact, it wasn't until the 1960s that the NRA started to change its position, and 2 decades longer before they got any traction. This is consistent, incidentally, with the history of the United States. It was the South that championed gun control laws in the 19th century, hoping to stop duels and squabbles. And the Wild West was not so wild. Frontier towns had incredibly strict gun control laws, requiring people to check their guns with the sheriff when they arrived. These towns were also crime-free, or virtually so. The famous Dodge City, getting out of Dodge, averaged 1.5 murders per year. There was little rape or theft. Many doors didn't have locks. They were more like Bowman and Carrington than present-day Williston. Is an organization allowed to change its mind? Certainly. But when it did, it was at the forefront of a major marketing plan led by future Supreme Court Justice Antonin Scalia and the organization he founded in 1982 to advocate for a fringe form of constitutional interpretation, originalism. This organization is the Federalist Society, the group that sponsors this debate that brought Ms. Froman here today. Justices Alito and Roberts are also long-term members. Until 1982, then, there was very little discussion about the original intent of the Second Amendment, and almost every single constitutional scholar supported the militia theory, that the Second Amendment exists to guarantee a citizen-based militia. For the next decade, Scalia and his group pushed through 125 articles on the individual rights approach and the Second Amendment, almost 10 times the amount of articles written on the amendment itself in the previous decade. The advocates dubbed their approach the standard model, an Orwellian abuse of language that stuck. Now, this doesn't mean they're wrong, but it does show that the claim that the Second Amendment defends unqualified individual rights has only been around since I was a teenager, and that people believe it mostly because of marketing rather than the arguments they provide. The preponderance of evidence suggests the opposite, that the individual rights approach is partisan and extreme. Now, any good constitutional scholar, which I'm pretending to be at the moment, will point to the legal history of gun rights. To oppose my view, he or she will show that after the Glorious Revolution in England, the right of the Protestants to bear arms was codified in the English Bill of Rights, and that since this served as a model for America, the founders had individual rights in mind. He or she will also point to Virginia's Constitution and Pennsylvania's and Vermont statutes in 1776 and 77, all of which argue for individual rights for gun ownership based on self-defense. However, what they will not emphasize is that the founders openly chose to not use the language of the previous laws. None of these previous documents included the qualification that ownership was connected to a well-regulated militia, but the American Bill of Rights did. The founders intentionally added the sentence, "The militia clause is there for a reason." This was not just a theory, though. It was a way of life. In the Revolutionary era, gun laws were strict. The founders implemented laws that required all free men between the ages of 18 and 45 to outfit themselves with musket, rifle, or other firearm suitable for military service. This mandate was enforced at musters, public gatherings held several times a year, where every person eligible for military service was required to attend, military gun in hand. Again, this doesn't preclude that individual rights were one of the reasons for gun ownership. But it does show that the Second Amendment is not just about personal protection, and that the first clause can't be jettisoned, as the NRA often pretends. What's more, a modern version of the militia approach still occurs in Switzerland. The Swiss, gun rights advocates will tell you, have the second largest ownership of guns outside the United States and 1/7 the amount of gun deaths. This, they argue, is proof that guns are not the cause of violence. What they won't tell you is that Switzerland has universal conscription. Every male is required to join the military when they come of age, and that soldiers bring their arms home during training. While the men are in the military, these firearms are automatic. But when they are discharged, former soldiers are required to modify the gun to fire manually. And gun violence? In Switzerland, 9 out of every 10 murders where attackers lived in the same household involved firearms, and 1/5 of the clients at the Zurich Women's Shelter Association reported being threatened with guns by spouses and partners. So yes, Switzerland has less gun violence than the States, but the proportion of guns involved in crimes is staggering. Furthermore, gun ownership requires passing an examination. All guns are registered and are now entered into a European-wide database of gun owners. I will add, by the way, that Switzerland also has universal health care, 7 times the amount of maternity leave mandated in the US, and homeschooling is banned in some areas of the country. Which of these other ideas will the NRA advocate for? To complicate matters, the term militia is ambiguous. Yes, it referred to the need for national and state defense, but it also referred to the people who enforced slavery, searched slave houses, and returned and punished escaped slaves. At the time, there was a vociferous debate around ratification of the Second Amendment because there was fear that the South, where blacks often outnumbered whites, the loss of these militias would mean a slave uprising and a destruction of the institutions necessary to keep slavery functioning. Patrick Henry was afraid that the new Constitution would disband these militias, so James Madison adjusted the first draft of the Second Amendment to refer to the security of the state, not the country, as he originally wanted. The amendment is about militias. Now let's be clear, I'm not arguing that gun rights advocates are racist. Gun control has been used for racist reasons as well. The KKK supported it to keep guns away from African Americans. Governor Ronald Reagan, when faced with Black Panthers' desire to carry weapons, responded, "There's no reason why on the street today a citizen should be carrying loaded weapons." He continues, quote, guns are a ridiculous way to solve problems that have to be solved among people of goodwill." Reagan was a strong supporter of gun control and said that it would work no hardship to the honest citizen. He was right, of course, but in this instant for the wrong reason. Does any of this argue for gun control? No. But it does show that the founders' intent was likely not to preserve national or state security, not individual rights alone. The originalist approach cannot be defended for other reasons that I'm sure we'll get to in the question and answer session. Gun control is a question that can only be addressed taking today's world, today's problems, and today's reality into account. The NRA approach to the Second Amendment is a fiction wrapped in a marketing campaign colored with paranoia. What are these fictions? Let's take the idea that guns prevent government from overstepping its bounds. I've heard it said that the Japanese Americans wouldn't have been interned in camps during World War II if they had had guns, and that the Jews would not have been exterminated. These ideas are ludicrous and offensive. First, all the Japanese Americans would have been killed. The combined rights of the US military and the West Coast Police and the National Guards would have been used to destroy the internal threat, household by household. Second, regarding the Jews, the Germans did not come for the guns first in order to seize power, as so many people on television have asserted. The Nazis didn't seize anything. They were democratically elected and supported by an enthusiastic population. Non-Jewish German citizens had access to many guns. Tens of thousands were found in German households by the GIs as they looted after the war. And more importantly, Jews made up 0.75% of the population. It took all the Allies and their entire war machine 6 years and 60 million deaths to stop the Germans. So guns do not protect us from overreaching government. They don't protect the people of Ruby Ridge or Waco, Texas, but do they make us safer? Not in schools. Columbine had armed guards, and virtually every law enforcement agency tells us that if teachers are armed, if there is an incident, the police don't know who to shoot. Not on military bases. Malik Hassan shot 13 people and wounded 30 highly trained soldiers at Fort Hood. Not if you carry a gun on your person. The odds of an assault victim being shot were 4.5 times greater if he or she carried a gun, and the odds of being killed were 4.2 times greater. Not if you're a woman. In 2010, nearly 6 times more women were shot by husbands, boyfriends, and partners than murdered by males or male strangers. A woman's chance of being killed by her abuser increases more than 7 times if he has access to a gun. And women in states with higher gun ownership rates were 4.9 times more likely to be murdered by a gun than women in states with low gun ownership rates. These figures are confirmed by Switzerland's experience, but 2 other sets of statistics stand out. Drivers who carry guns are 44% more likely than unarmed drivers to make obscene gestures at other motorists, and 77% more likely to follow them aggressively. Guns make you hostile. They don't create a polite society. And in the last 30 years, there has not been a single mass shooting that was stopped by an armed civilian. In emergency room shootings, there's a 20% chance that the gun was actually taken from a guard. You know what does stop mass shootings? Small capacity magazines. Gun rights advocates claim that there's little difference between high-capacity magazines and reloading, but we know this isn't true. At the Gabrielle Giffords shooting, the assailant was stopped by a 61-year-old woman who wrestled a second magazine from the shooter while he was trying to reload. He was then hit over the head with a chair and tackled by a 74-year-old man. None of them used guns. In short, for every time a gun is used in self-defense in the home, there are 7 assaults or murders, 11 suicide attempts, and 4 accidents involving guns in or around a home. Facts made more graphic by a statistic that got a lot of recent attention. More Americans have been killed by guns in the US since 1968 than all the battles since 1775. That's just in my lifetime. I'd like to make 2 more comments. The first is to the libertarians in the room. Most of you don't know me. You don't know my 20-year career-long flirtation with libertarianism. I'm an Adam Smith scholar. I've gotten a handful of fellowships from libertarian organizations. In May, I'm at a symposium by one of them. There are 2 key precepts to any libertarian point of view: freedom of choice and absolute responsibility. But the second has been abandoned by the NRA. Libertarians believe that people are responsible for their own actions and their own property. They do not blame others for their own neglect or choices. Thus, nothing is more consistent with the libertarian point of view than registering guns and including serial numbers on every bullet. It is only when a person's property is traceable, when we can figure out who shot whom, that we can live in a libertarian world. If you don't like the idea of serial numbers on bullets, then you are not ready for the freedom that libertarianism demands. Finally, I will say this: the NRA position has no place in a democracy. The United States is built on compromise, and we have found the middle ground on everything. We compromised on emancipation. Slaves never got their 40 acres and a mule, and their descendants have never seen unchallenged affirmative action. We compromised on women's reproductive rights. No one gets abortion on demand. In North Dakota, no one really gets an abortion. We compromise on education. It's accessible, but not free. Sometimes we have to draft our citizens. Property can be seized by eminent domain. Children can be taken away from unfit parents. Some of these positions infuriate me. But as an American, I accept that public policy is a slow, steady compromise. The only ones who don't understand this are the gun rights ideologues who side with the NRA. They think they're special. They think the rules don't apply to them. They think their wants are the only pure ones. They're wrong. I'm willing to compromise on hunting. I've said so publicly on my radio show. I'm willing to compromise on very small capacity manual fire weapons for home protection. What are they willing to compromise on? Not background checks, not fully automatic large capacity firearms, not anything. That kind of rigid ideology has no business in a pluralistic country. It has no business in America, and frankly, it has no business at a law school dedicated to teaching the immeasurable importance of the rule of law. Thank you.
Good afternoon. Thank you all for being here. I want to thank the Federalist Society for inviting me to come speak today, and I want to thank Professor Weinstein for agreeing to debate us, because Basically, you get better food if there's someone on the program debating the invited speaker. I want to talk a little bit about a couple of things. First of all, I'm going to throw out a few questions, and I hope maybe by the end of the talk today, or if you go home, you think about some of these questions. And some of the answers, I think, have already been sort of thrown out there on the table for you. So, first question was, when was the NRA founded, and why, and by whom, and for what purpose? Second question is, when was the last time the militia, as described in the Second Amendment, acted in defense of our country? The third question is, what do you find when you Google the two words Kozinski, Kozinski, and doomsday? Don't pull out your PDAs or cell phones and do that while I'm talking, please. There's a lot of misinformation out there. There's a lot of misinformation about the statistics relating to gun control policies. There's a lot of misinformation out there about the NRA, some of which you've already heard today. A lot of gun control advocates attack and try to demonize the NRA instead of addressing the facts that relate to gun control. What I'm going to try to do today is talk a little bit about the facts, a little bit about constitutional law, and a little bit about policy issues. We have a very short period of time to do it, so obviously I'm not going to be able to cover everything. My first question is, how many of you are law students and you have taken or are taking constitutional law? A few. Okay, more than a few, about half. Let me just ask somebody, have you guys studied the Heller and or McDonald cases in con law? Are those on the agenda? Yeah? Okay, good. When I went to law school, which was many, many years ago, we did not discuss the Second Amendment. The Second Amendment was a non-issue in constitutional law. In fact, in our big fat case book, there was not a single case, there was not a single discussion, there was not a single mention of the Second Amendment. However, the authors of that case book did have the intellectual integrity to reprint the Bill of Rights in its entirety in the appendix, so we can be grateful for that. But what's really wonderful about the Heller and McDonald cases is they've given us all of us who are interested in this issue, no matter what side you're on, an opportunity to talk about and debate this in the context of U.S. Supreme Court cases. What we've got going on right now is a discussion about, obviously still about the Second Amendment, not so much what it means in a pure sense, because I think the Supreme Court has addressed that in the Heller case. The Heller case was a case which held that the Second Amendment guarantees an individual right to keep and bear arms unrelated to your service in a state-sponsored militia. And that, as Professor Weinstein said, was certainly a debatable issue before Heller. There were people who held that this was a collective right to be exercised only in conjunction with your willingness to serve in a state-sponsored militia, and then there were others who believed that this was an individual right and that right existed for people independent of their service on behalf of their states, because if you have a tyrannical government, you need to be able to have firearms to address that, as our founding fathers did when they separated from Great Britain. And the idea that we would never be able to protect ourselves from a tyrannical government, well, yes, it's true that the government may have more powerful weapons than individuals do, but if you look at Jews who had guns in the Warsaw Ghetto, if you look at Afghanis who had rifles fighting Russia with tanks, what you'll find out is you may or may not be able to win that fight, but you're going to sure cause a lot of problems for your tyrannical enemy. Wealthy people like New York Mayor Michael Bloomberg are pouring millions and millions of dollars into media and public relations campaigns to demonize guns and to demonize gun owners and to demonize the NRA. Thank goodness for the internet is all I can say, because at least people get to hear the other side of the story and they're not limited to what they read in the New York Times or the LA Times or the Washington Post. Let me talk a little bit about constitutional law for a minute. In 1904 in New York City, the Sullivan Act was passed. That was an act that was passed to require registration of guns, and it was designed to help New York City law enforcement officials deal with crime, much of which they believed was being committed by immigrants to this country. In 1934, the National Firearms Act was passed. That was an act which required registration of fully automatic firearms, destructive devices, short-barreled rifles, And what was interesting about that, and the reason I want to talk about that, is because since 1934, all fully automatic firearms are required to be registered. The assault weapons that you hear about in the media today are semi-automatic rifles, not fully automatic rifles. So let's get that straight right away. I think the media sometimes tries to imply that these are fully automatic firearms. I think many people are understandably concerned about that because they're not widely owned in this country. But it is legal in some states to own fully automatic firearms. It requires full registration, fingerprinting, background checks, photographs, about a 9 to 12-month wait. And most of the registered fully automatic firearms in this country are owned not by criminals, but by very wealthy people who are like doctors and lawyers and airline pilots and people who can afford to collect them and take care of them. And because they are expensive and unwieldy for the most part, it's something that's not generally chosen by criminals to be used in crime. In fact, the firearm that is the choice of criminals is the ordinary handgun. Very few crimes are committed with rifles in this country, which is why it's so interesting that much of the attack is on rifles. But going back to constitutional law for a minute, so we have the National Firearms Act in 1934. In 1939, there was a U.S. Supreme Court case called the Miller case, in which a bank robber had transported a short-barreled shotgun across state lines, and it was unregistered. In defending himself from the bank robbing crime, he raised the Second Amendment, and the U.S. Supreme Court took up that question. It actually didn't decide it, because it couldn't decide whether, there wasn't enough evidence in the record, the court said, to decide whether a short-barreled shotgun was in fact a militia weapon, as described in the Second Amendment. So they sent it back to the lower court for more fact-finding. Unfortunately, Mr. Miller got himself killed in the meantime, and the case never actually came back to the U.S. Supreme Court. So for a very long time, from the time of the Miller case until the time of the Heller case in 2008, I believe, you had no real description of the meaning, no decision on the meaning of the Second Amendment. I guess one of the other questions I want to ask you, and I'll ask if anybody knows this today, is if the Heller case, which was a test case on the Second Amendment, the meaning of the Second Amendment, whether it indeed protects an individual right, why would you bring that case in Washington, D.C., very unfriendly jurisdiction for guns? Why didn't you bring it in Texas or Arizona, a jurisdiction that was a lot friendlier? Does anybody have an idea? Anybody who's taken con law have an idea as to why it was brought in D.C. as opposed to a friendly gun state? Is D.C. a state? Okay, what law applies in the District of Columbia? Federal law. D.C. is a federal enclave. It's not a state. So the Second Amendment applies directly in the District of Columbia, unlike other states where you would have an incorporation issue. The reason that case was brought in the District of Columbia was they wanted it to be a pure test of the meaning of the Second Amendment, which applies in D.C. just as if that were the state law in the District of Columbia. So when Heller was decided, I think the day after the Heller case was decided, a second case called McDonald versus City of Chicago was brought. And that was brought to test the law in the City of Chicago, which was pretty similar to the DC law that prohibited the ownership of all guns, including and especially handguns, in the city. And the idea there was we now had the Heller case from the Supreme Court as precedent. Now we were looking as whether or not the Heller case applied to the states to preclude them from preventing people from exercising their Second Amendment rights. And the McDonald case was decided 2 years after Heller and basically said yes. The Second Amendment applies to the states as well as to the federal government. Now, not every right in the Bill of Rights has been incorporated to the states, but the Second Amendment now has, as well as the First Amendment and a number of other amendments. So it wasn't a foregone conclusion that that was going to be the outcome. In fact, both Heller and McDonald were decided by a 5-4 vote on the Supreme Court, which is why it's so important to, watch the Supreme Court and see how the justices are coming out. What's really important, though, about Heller and McDonald is what is going to come out of that. We now have, does anybody know what gun was involved in the Heller case? What gun it was that was the subject matter of the challenge? It was a handgun. It was a revolver. A man named Dick Heller, who worked as a guard at the Judicial Building across the street from the Supreme Court, carried a gun every day for work. but he lived in the District of Columbia, and when he went home at the end of the day, he couldn't take his gun home with him because of the DC law. So that was the issue, was whether or not a law-abiding person could challenge the district's ban on handgun prohibition based on the Second Amendment. And it turned out that Mr. Heller was indeed entitled to be able to have his gun at home for self-defense. The self-defense aspect of the Heller case was fascinating because self-defense isn't mentioned at all in the Second Amendment. The Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Doesn't say anything about self-defense. There are a number of state right to keep and bear arms provisions which do talk about self-defense, but not the federal one. And yet that's what the Supreme Court called out, was the right of people to have firearms in their home for self-defense. But now the question is, what firearms? Okay, you can have a revolver, but can you have a semi-automatic rifle? Can you have a fully automatic firearm? Can you have firearms that have high-capacity magazines? Those are some of the questions that are going to be addressed as we move forward that weren't specifically answered by Heller, although there's some suggestions and some hints in the Heller case. You know, one of the other questions from a con law standpoint is who has standing to bring a Second Amendment lawsuit? When the Heller case began, it was called Parker versus United States because the first plaintiff was a lady by the name of Parker, last name Parker. However, by the time the Heller case got to the Supreme Court, all but one of the plaintiffs, Mr. Heller, had been dropped from the case because they didn't have standing to bring the action. For those of you who don't pay attention when the discussion is about standing in your law school classes, beware. You know, as lawyers, there could be nothing worse. Nothing I could imagine that would be worse than taking your case all the way to the Supreme Court for your client and then getting dumped because lack of standing. You want to make sure you address those issues at the front end. But the question is, who has standing to bring a case? What standard of scrutiny should be applied to Second Amendment issues? For example, should you have strict scrutiny? Remember, this is a specific enumerated right in the Constitution. And so what standard of scrutiny should apply to this? Strict scrutiny or the most liberal standard, which would probably justify just about any law that could be passed, the rational basis test, or is it something in between, which the courts refer to as intermediate scrutiny? And you'll see, for example, that as a practical matter, what kind of right is being exercised may make a difference as to what type of scrutiny is being applied. For Mr. Heller, obviously, the Supreme Court in Heller said rational basis won't cut it. They implied that strict scrutiny was the right to be applied, although they didn't formally hold that. But if you have, let's say, a collector, a firearms collector, they're not using their firearms necessarily for self-defense, they're collecting them. Should a different standard of scrutiny apply to the right of those people? And I'm talking about rights now, but I think it's important to distinguish, especially when you're doing constitutional law analysis, between interests of people in owning firearms and their rights, constitutional rights. I'll give you another example. A lot of people say, for example, that it's very important to have firearms education and training, and I agree. I am in favor of more training. I'm in favor of training as often as you can. I think it's important from the standpoint of safety, personal responsibility. But should we require training before someone can own a gun? Should the federal government implement a training requirement before you can exercise your Second Amendment rights? Think about your First Amendment rights. Think about your right to vote, your constitutional right to vote. Should we have a literacy test before people can vote? Should we have a test to determine whether you know the issues before you can vote on legislative matters? Those kinds of tests have been held to be unconstitutional. So while they are a good idea, they may not, and something as a policy matter we all might want, they aren't necessarily constitutional. So you need to distinguish between what's constitutional and what's a good idea. The central fact about gun violence that the media and many folks who advocate for gun control ignore is that virtually all of its perpetrators are previously convicted criminals with multiple prior criminal violations. A few of them